I am here with my co-counsel, Jessica McGrew, on behalf of the appellant, Bugware, Inc., who was the party that was the plaintiff in the court below. I would like to reserve 3 minutes for rebuttal, please. The issues before this court today are whether the appellant's complaint adequately stated causes of action against Appellee Williams individually for breach of contract and for misappropriation of trade secrets, which is a tort that has now been codified. More specifically, appellant seeks reversal of the trial court's order dismissing Appellee Williams and does so on 4 bases. The issues before the court today are whether the trial court's order improperly negated portions of the contract at issue in this case by finding it did not bind Mr. Williams individually, and also whether the trial court had to engage in improper factual determinations on a motion to dismiss to reach that result.
Well, counsel, on that point, let me ask you, as I look at the contract, it can be interpreted, I think, a couple different ways based upon how it's written about who the parties are. Is that your view as well?
No, Your Honor, I believe it can only be interpreted unambiguously one way, and that is that Mr. Williams is a party individually to the contract, which is what I argued in the trial court.
Well, I guess what I'm saying is, I was thinking it was one or the other, not both. You're saying perhaps both. In other words, you've sued both the individual and his company.
I believe it imposes obligations on both parties, yes, Your Honor.
Okay, I see what you're saying, okay.
I also think another issue before this court today is whether the trial court's order dismissing Mr. Williams individually as to count 2, the trade secrets claim, improperly granted relief that was never raised in the motion, was never argued, and exceeds and violates the due process rights of the appellant.
If I could follow up on that issue on the trade secrets. Trade secret is typically something that is either a formula or either some sort of technology and so forth. Is it, in this case, is the trade secret in Mr. Williams' head, or is it on a shelf in the corporate office in the Williams Environmental is located?
In this case, Your Honor, the field of nanofossil paleontology involves thousands and thousands of ultramicroscopic organisms that, when examined in the strata of soil, determine the age of soil and therefore the presence or absence, likely presence or absence of oil. Those nanofossils are classified, and they have thousands of different genres and different pictures. The part of the trade secrets involved in this case involved, and as alleged in the complaint, involved not only the development of a database of information related to the identity and characteristics of those nanofossils, but also information about strata and where those are typically found that comes from the appellant's clients. But that actually is more of a factual issue, Your Honor, and accepting the allegations of the complaint as true, the allegations of the complaint detail the various things that were that constituted trade secrets. And the trial court's order eliminated Mr. Williams as a potential defendant under the trade secrets count. The only, the only basis raised in the motion to dismiss by the defendant was that the trade secrets, we did not have standing to raise the trade secrets issue because, to the extent we were claiming on behalf of Bugware's oil company clients. Well, that's a long way from saying that there's no personal liability on behalf of someone who is a company person, company employee who actively engaged in the misappropriation of trade secrets, which was alleged in the complaint. And accepting all the allegations of the complaint as true, common law misappropriation of trade secrets is a tort. And as you know, under the doctrine of master-servant, the plaintiff has the right to sue the servant or the master or both. In this case, we sued both for common law and statutory misappropriation of trade secrets. There's simply no basis in the record, nor was any basis requested for dismissal of Mr. Williams as to count 2.
How long has the corporation been in place, the Williams Environmental and Geological Services?
Your Honor, I don't know that that was alleged in the complaint, but I believe it was formed prior to his actual, Mr. Williams' actual contract with Bugware, Inc.
Right, well, because the contract was with the company as well. I mean, the company was mentioned in the contract with
Yes.
Bugware, so it must have I was trying to see if this has been in place for
The company, I believe,
5 years.
speaking from memory, Your Honor, I believe the company was formed maybe even in 2008 or earlier. But the field of oil field paleontology is so highly specialized that there are not a lot of people involved in this particular profession. In fact, as we alleged in our complaint, it requires extensive training, and as we also alleged in our complaint, which must be taken as true on a motion to dismiss, the decision of whether to drill or not drill, stop or not stop, involves millions and millions of dollars that the oil companies do not take lightly. So the issues continuing before this court are whether the trial court has inherent authority to enforce that contract that we submit it does against parties actively engaged in the breach, even if they were not, let's say, named as parties to the contract. And finally, whether the doctrine of inconsistent positions precludes Appellant Williams from claiming at this stage of the litigation that he is not personally responsible under the contract. We suggest that the courts...
If we were to look at the contract and find some ambiguity, that on one hand it looks like he's signing on behalf of the corporation, seeming just to bind the corporation. On the other hand, it appears there are some provisions of the contract that only make sense if it's talking about an individual. What do we do if we see it ambiguous? I know you see it as unambiguous, but if we were to see we can't make sense whether it was intended to bind one or both or who, what's the recourse?
I think the recourse, Your Honor, is to reverse and remand for further proceedings, leaving Mr. Williams as a party defendant in the case. If the contract's ambiguous, then the next step in the trial court is to allow the defendant to file an answer and presumably affirmative defenses to which we would then have an opportunity to reply. And obviously the intent of the parties is the touchstone here for the court's decision in the trial court. If the contract is ambiguous, then parole evidence will come in to explain why it was essential and why, as alleged in paragraphs 23 and 24 of our amended complaint, the parties intended for Mr. Williams to be bound individually.
Would that disposition resolve the other issues you raised, or are those separate?
I believe that disposition would resolve all the issues, Your Honor, because although count 2 is not really a contract count, Your Honor, it's a statutory and common law count for misappropriation of trade secrets. So I believe that if the court found that the contract was at the very least ambiguous and reversed and remanded as to count 1, I still think the court would have to deal with count 2 somehow, because it was not a contract claim. It's based on trade secrets law, which goes back hundreds of years in the common law and certainly has now been codified in Chapter 688. So I believe the court would still have to reach the trial court's decision on count 2. The facts of this case, Your Honor, are that Mr. Williams and the company WEGS entered into a contract in 2010 in May to perform oilfield paleontological services for Bugware, Inc. On September approximately 13th of 2013, knowing that this contract was in place, Mr. Williams refused to take any more work assignments and almost immediately went to work for another company that performs oilfield paleontology services in the Gulf of Mexico in direct violation of the covenant not to compete, and in direct violation, we submit, of the confidentiality provisions of this agreement.
Well, remind me, is Mr. Williams acting on, in getting that new business, is he working as an independent contractor through his company, or is he working with them as an individual? Is that alleged in the complaint?
I believe we alleged that Mr. Williams individually, I honestly would have to check, Your Honor. I think it's, I know he is performing the services. He's the only officer, director, employee, only person, as alleged in our complaint, he's the only person who's ever been qualified as an oil field paleontologist on behalf of Williams Environmental and Geological Services. He's the only employee they've ever had. So his violation can only be done by him individually because he's the only oil field paleontologist. So his work for the competitor is done by him individually. A few weeks after Bugware, Inc. discovered the new employment of Mr. Williams, suit was filed seeking both injunctive relief damages and injunctive relief and damages under the misappropriation for trade secrets. The contract at issue in this case, Your Honors, names the parties to the agreement in the opening paragraph. And the parties to the agreement are an essential term of the contract. This is not a recital where the contract went through a bunch of whereas clauses and then said, now herefore the parties agree as follows. The opening paragraph talks immediately about who the parties are. In addition, I think it's compelling that there are so many personal obligations imposed in the different paragraphs of the contract. For example, if the subcontractor dies during the course of providing services to Bugware, the contract provides what happens to the compensation that otherwise would have been owed to the subcontractor. Well, clearly, a subcontractor that's a company doesn't die, Your Honors. It may cease to exist, but it doesn't die. There are multiple other instances in the contract where personal obligations are imposed, behavioral obligations, obligations about the chain of command, obligations about what to do with the...
I'm sorry for interrupting, but who prepared the contract?
I'm not sure that that's alleged in the complaint, Your Honor. I'm pretty sure that somebody associated with my client prepared the contract. But I would point out to the court that under 542.3351H, when dealing with a non-competition covenant, the court is precluded from considering or construing for or against a particular party based on draftsmanship. The statute that the legislature adopted said that's no longer. In fact, the court is to liberally construe covenants not to compete to effectuate their purposes and should never construe them and is mandated not to construe them against the party who drafted them. Your Honors, based upon the personal obligations, we think it's clear that the contract and the parties unambiguously intended for Mr. Williams to be bound individually. In addition, we believe there's no basis for dismissing Mr. Williams as a party to count two. Finally, Your Honors, I would just like to point out the doctrine of inconsistent positions in this case. The defendants filed a counterclaim to the initial complaint in this case, which Mr. Williams individually sought relief under the contract. Now, the doctrine of inconsistent positions is a little bit different than the judicial estoppel doctrine. The judicial estoppel doctrine usually precludes inconsistent positions in subsequent litigation. But the doctrine of inconsistent positions prohibits a party from basically having its cake and eating it too. And in this case, it's a bit disingenuous for Mr. Williams to claim damages under the contract and then turn around and claim individually and then turn around and claim that he's not a party to that agreement.
Stushman, you're well into your rebuttal. You're welcome to continue, but...
I think I'll reserve. Thank you, Your Honors.
Good morning. Good morning, Your Honors. Stephen Turner for the Appellee, and I have Misappropriation with me, who was on the brief. Let me first address the ambiguity issue. That was not raised below, not raised on appeal. It is waived. There is only an issue here of does the contract clearly and unambiguously incorporate Mr. Williams individually. The contract provides that he is a subcontractor, not an employee. It's very specific. There's nothing wrong with having a company subcontractor. And it is the subcontractor, by the way, that is with other jobs. That was always the case. He had a company, the company came in. I would submit that it is unequivocal under the law that only the signatory, when it says president and the company, that's who's bound. And indeed, the statute 542.335A1 is very explicit that if you do not sign, you are not subject to a covenant not to compete. It's unenforceable against you. So it cannot possibly be anybody other than the company who is bound.
How can the company die?
You just have an inapplicable provision, Your Honor. There are many provisions in a contract, in a form contract, that don't apply to a situation. They have a form contract that they use to apply to this particular situation. But they hired a subcontractor company, and that is very clear. The case that's the most on for is Porlick. We cite in our brief, 683 Southern 2nd at 547 and 545 at page 547. It pretty much is dispositive of all of the claims here, because in that particular case, the court was dealing with an attorney, a PA, and the court held, no, the fact that you say Mr. Jones of the PA doesn't mean it's not the PA, and doesn't put Mr. Jones in responsible. Mr. Jones is a representative. He is serving in his representative capacity, not the person who is responsible. Now, yes, sir.
I guess to me,
this is fundamental.
that argument would, that there are certain inapplicable provisions as a foreign contract might carry a little more weight if there weren't particular provisions in the contract that somebody, wasn't initialed, but somebody went through and lined out. So it seems obvious that the parties in deciding what they wanted out of that form contract and didn't want out of that form contract made some strikeouts, and there are provisions about behavior and things that only speak to an individual. I mean, how are we to deal with that?
Well, there was a representation in the contract that he had, I forgot, that Mr. Williams that somebody had not been involved in the business before, and that just wasn't true. He's very experienced. He's got his degree in geology. I mean, all of this is sort of hokey pokey anyway, because you've got knowledge from studying all this stuff. But in any event, that's what was struck out. Form contracts frequently or not have provisions in them that, you get all kind of provisions, force majeures that have no applicability because we're not, there's no tornadoes in Florida. I mean, so you get all kinds of things in contracts. The point is, who is the person that signed this contract? Who is it to look to? And the cases over and over say, especially with covenants not to compete, where you have a statute that says if you don't sign, you're not subject to that. I repeat again, 542-335A1, if you do not sign the covenant, it is not enforceable against you.
Well, who signed it on behalf of Williams Company?
He signed it in a representative capacity. That's exactly what the Fortunate case talks about.
What's different, though, is if you have a mega corporation and the president's or CFO, someone signs the contract, but someone else is actually performing the service. But here you have one person, one company, one provider.
Well, you want to collapse the company, but that's not the way it is. The company is entered into the agreement. That was the choice of, that was who was the bargaining, the parties bargained, and that's who signed the contract. Now, if the intent was to make Mr. Williams subject to it, the intent is not evident from the document, and it's not put in there.
Maybe correct me if I'm wrong. I thought that one of the very first provisions of the contract said it's between Bugware and Mr. Williams of such and such.
That's exactly what the Porlick case said. The court, that is exactly the Porlick case where it said Mr. Jones of the PA. And the Porlick case said that it's the PA that's liable. He is in his representative capacity, and the signature line very clearly says Williams Environmental Services by Mr. Williams as president.
What if Bugware chose just to sue Mr. Williams and not the company?
Well, they have no basis to enforce the covenant. Now, if they enforce the covenant against
no, but bear with me. Just say it was the trade secret claim. Let's say it's not the covenant, it's a trade secret claim. We want to sue Mr. Williams because he has trade secret knowledge in his head. He's going out and competing and getting business. Well,
if they wanted to do that, that's fine, but that's not what they alleged. First of all, they haven't raised, we're switching to the trade secret, they haven't raised the issue of the propriety of that. They've raised a due process. You can't just come in and flip-flop. We briefed the issue of due process. So the due process claims is fails. They didn't come in and say it was proper, the merits or so forth. But I would point out to the court that the complaint itself makes very clear that it's dependent upon the contract. It makes very clear in the allegations of the account that this duty arises because it's contractual. And you'll see in paragraph, I think it's 20 or 34 and 20, they make it clear we're enforcing the contract through these remedies. So they waived any, again, we're back to waiver. They have waived the contention in this argument that the trade secret claim was dismissed improperly, other than due process. That's the only issue they're raising.
maybe I'm confused, because
Yes, sir.
what I hear you saying is that their claim against Williams is that it's only pursuant to a contract, and that this trade secrets claim is subsumed within that, or at least a part, and not an independent claim.
That's correct.
That's what
Their
you're
claim in paragraphs 20 and 34 of their complaint make it very clear that it depends upon the contract. So they're enforcing the duty undertaken under the contract by alleging trade secrets. They're trying to change their whole case. Not only are they trying to change what they alleged, but they're trying to change their point on appeal, which was a due process point. And that's what we briefed, and that's what's in front of the court. Let me get back to your first point on whether the officer is bound is something that you can do through the company. So you can bind once you issue an injunction, you can bind the officers under the common law and under Rule 1.610. So if you issue the injunction, then the officers and employees and so forth are bound by that. But they're not personally liable, and they're not liable for attorney's fees. Even under the statute, they're not liable for attorney's fees. Only the signor is liable, and that's the difference here. So it's important that we carry out this as the case law and as the parties agreed among themselves.
So in your view, they've argued that this contract clearly and unambiguously binds the individual. You've argued that it clearly and unambiguously binds only the corporation. So those are, in your view, our only two choices.
And that was what was in front of the court below. You can't come into this court and raise something that you haven't raised below. There was no allegation or contention of ambiguity. The contention was, just as you've recited. And in fact, that is correct. I believe it's the correct provision that it is clear and unambiguous that only the company who signs the agreement is going to be responsible. It's very clear in this contract that the Williams Environmental is to be held liable under the covenant and be responsible. Now, they're responsible for their agents. If they hire an employee, they're responsible. Mr. Williams is responsible through the company. So that's the allegation. That's where we're going in this particular
But isn't a trade secret claim more of a tort?
It can be. It can be a tort if you implement it through the statute. It can be a tort. But I'm suggesting the court wants to go into the merits of the trade secret claim, first of all, and I want to make clear that that was not raised as a point of appeal. But if you want to go into the merits, what I want to point to the court is on paragraph 20 and 34 of their complaint. They make it clear that absent the contract, the parties would be free. That's the language that was pled. Absent the contract, the parties would be free to take this knowledge about bugs, which I don't understand why it's a big deal, because it's taught. And it's information that you can get from textbooks. That was the testimony at the temporary injunction hearing. But in any event, regardless, the point that I'm getting to here is that the way this is pled, it is a contractual enforcement by remedy of the statute. So it's not pled that way, and it's not raised on appeal on the propriety. What's raised on appeal is that there was no due process accorded with respect to the dismissal of count 2. And so that's all I'm saying here is in front of the court today are these issues.
Is there an amended complaint in this case, or is there an amended complaint or just a complaint? Was it?
I believe it's the amended complaint.
I'm only finding a complaint, and I don't see those paragraphs you've provided there, but I'm just maybe missing it. You're saying paragraphs 20 and 34? I've got the original complaint here.
I think there's got to be an amended complaint, because I thought one of your responses was, as to this inconsistent position, was that once you filed counterclaims in response to the original complaint, but then they amended their complaint and you simply answered it.
It's plaintiff's first amended complaint, Your Honor, and reading from paragraph 20 of the first amended complaint, absent the non-competition and confidentiality provisions like those in the contract, Williams and WEG, Williams Environmental, and other subcontractors would be free to use Bugware's client proprietary information and Bugware's developed processes. By the way, the count 2 in the motion was just poorly worded. It was really point 2 of the motion, which was going to both defendants and saying you don't have standing to raise this issue about clients' proprietary information. We're not here on that because we agree that that's not involved. What we're talking about here is the dismissal of Mr. Williams individually as liable under the contract or responsibility with respect to the contract.
You're saying paragraph 34 somehow.
Paragraph 34 carries
Limits
that
them.
forward and says, Bugware is entitled to injunctive relief and to enforce the terms of the party's agreement or contract as to the use of dissemination of confidential information. So it's under the trade secrets count. It's showing you the link here that they're pleading it. So the way they pled it was tied to the contract. And if there's no responsibility on the contract, then there'd be no responsibility here. We don't get into that because they didn't raise that to the court. They didn't raise that as an argument.
Well,
What they've raised.
How else would a trade secret get protected then?
Well, you could have an independent trade secret. You could steal a trade secret.
I mean, you could have a verbal agreement. I'm going to give you a trade secret. Here's the formula to whatever.
You could, but we
But
don't.
that's a contract.
We have it here in connection with a non-competition agreement. Judge, they're stuck with their pleading. I can't
Yeah,
create a
but
different pleading.
I don't disagree with that. I'm having to call it a senior moment. I don't see how they have to allege a contract and how they can't allege a trade secret claim and.
Well, we're off on something, Judge, again, that I don't think we need to be off on because they didn't raise this point. Their point, too, is you did not afford due process. That's what's in front of the court in regard to count 2. But the merits of count 2 are, can you allege a trade secret violation? Sure, you can allege a trade secret. You don't even have to be in privity to steal a trade secret. A lot of trade secrets are stolen and you're not in privity. But here they put the obligation through the contract.
So they amend their complaint on remand.
Well, but they didn't do that. They didn't come in and suggest that it be done.
Okay.
They didn't suggest that it be done. All I'm saying is it was dismissed, and here's the count, and they didn't ask for leave to amend or come in anything else. The issue was, are you liable personally under this complaint and contract? And that was in front of the court. In sum, the contract, we believe, is very clear that the contract binds the company. That doesn't preclude the court on, if it issues injunctive relief, to issue a relief against the officer of the company as the rule allows, as the rule permits, or if the company is participating, that is, the individual is participating in the breach or the violation, you can enjoin the officers or the employees of the company. But as far as personal liability and responsibility of the individual, it doesn't lie here. And that's the way the contract was drawn, and
So as long as Mr. Williams doesn't perform this work in his, or at least this company's capacity, he can do it.
he has no liability. Judge, the distinction is he has no liability. What he can do is be under the injunction. So if you find an injunction, you can order that he must comply with the injunction. If that you can do. He would have, for example, if you did that under the case law, I apologize for the case, I think it's the Bauer case, where they held you don't have liability for attorney's fees even in that scenario, even when you're made subject to the injunction by virtue of the fact you're an officer of the company. So that comes once the court shapes the decree. At that point, the officer would be involved. The officer could be subject to the injunction.
So, it was a late night last night watching
That's
football,
okay.
but if at the end of the day the trial court says, as I guess it has, this applies to the corporation, and thus I'm hereby, if we get to the point the trial court says I'm hereby enjoining this LLC from doing this work.
Yes, sir. Forcing the covenant against the LLC, that's right.
How would that then preclude Mr. Williams from doing the work?
He couldn't. He would be included in the injunctive relief. Under Rule 1.610, you include the officer of the company under the injunction. You include he doesn't escape the responsibility.
So he quits his job. He says, I'm not the president anymore.
Well, then you get an evasion issue. You can't, that's a whole
Then it's
other.
his individual capacity then.
Well, if he tries to get around it, then you get into evasion, and that's a whole other, that's not in front of the court. We don't have those pleadings. He's not invading. He started as a company. He worked for them as a company, and he's working now as a company, and the company is paid. I don't see the problem. I think if you want to get into what ifs and what could happen, then we need another complaint. But we don't have that here, and that's not what we've got. We've got simply a very much like this Porlick case, very similar, where the LLC, where the PA there was the one on the line, not the individual. And the court saying it doesn't matter that it says of, it doesn't matter that it says you in the contract, it doesn't matter that it says he or she. That's not what matters. Who signs the contract? Whose name is on the contract? That's who's responsible to perform.
All right, thank you, Mr. Turner.
Thank you, Your Honor.
Madam Clerk, if you'll add another minute and a half or to Ms. Dushman's time.
Thank you, Your Honor. A couple things. First of all, this case is here on de novo review. The trial court didn't make any findings in its final written order as to whether the contract was ambiguous or unambiguous. The only thing the court said was the signature line controls. He signed corporately under the signature line, or not corporately, but as an LLC company, therefore that's it. That's as far as the court would go. So on de novo review, certainly if this court reviews the record on this motion to dismiss and determines that the contract in its mind is ambiguous, then this court certainly has the ability to do that on review. Secondly, Your Honors, Mr. Turner cited to 542.335 and the statute of frauds contained in the statute for requirement of a signature. That argument was never raised in the trial court. It wasn't raised in their motion to dismiss. And in fact, it's an affirmative defense. We're here on a motion to dismiss. Had they raised the statute of frauds that's contained within section 542.335, we certainly could have raised a reply to that, but we're not even at that stage in the pleadings, Your Honors.
Let me ask this question. If I understood, and I may very well not have understood what Mr. Turner was saying, because of my fault, not his, but it sounded like it didn't really matter whether the injunction was entered against the individual or the corporation if the contract was between the individual or the corporation, if the injunction the court entered could ultimately bind the individual. What am I missing? Well,
there's claims in this case in the amended complaint, which is what's at issue here, the amended complaint, not the original complaint. There are claims for injunctive relief and for damages, Your Honor. So if Mr. Williams is individually responsible, then he's individually responsible, forget about the equitable relief, on money damages claims as well as attorney's fees under the statute. But, Your Honors, I'd like to go to the Compton case for just a minute that Mr. Turner cited. The Compton case was resolved on a motion for summary judgment. The parties submitted affidavits and submitted discovery evidence as to the parties' intentions. We're not there. We're on a motion to dismiss. So the meaning of the contractual terms, the use of the he and she, the use of the term what's going to happen upon the death of the subcontractor, all those things go to the parties' intentions. But we never got there, Your Honors. Finally, I would call the court's... Would you have an obligation to raise at the trial court, Judge, we think this is clearly applicable to just the individual, but at a minimum it's ambiguous. I mean, did you make that argument below? And if not, did you have to? We made the argument below that it unambiguously bound Mr. Williams individually. I believe that at this point, when all we had was a motion to dismiss and our reply memorandum, we're not talking about the pleadings yet. I certainly didn't have to anticipate that affirmative defense in my complaint. The only thing that was at issue really was the complaint and the motion to dismiss. And so it seems to me if they're going to claim that it's unambiguous and I want to claim that it is, then I can raise that as an affirmative defense if we get there in the pleading stage. The only other thing I would call your Honor's attention to is the record at page 40 is where the amended complaint, and at page 41 in the trade secrets count refers specifically to the statutory claim. It says that the plaintiff is entitled to enforce the trade secrets violations under both the statute and the contract. So it was a claim that involved a statutory claim for the tort. And why was that not raised in the trial court? Because it wasn't raised in their motion to dismiss. The only thing they raised in their motion to dismiss was standing. They never got to the merits of the
Thank you.
trade
Exceeded
secrets
your
claim.
additional time.
Thank you, Your Honors.
Counsel. Our last case will be United States Fidelity and Guarantee versus